introductory session to trademarks. Trademarks is something that, whether people know it or not, affects all small business to some extent. Some of this may be going over stuff that you're very familiar with, but hopefully I can offer some insights along the way. And as I said, I'm happy to answer questions. There should be plenty of time at the end to do that. So what am I going to look to cover today? Well, we'll start with the very obvious thing. What is a trademark? Then I'll discuss the difference between a business name registration and a trademark. It's a common misconception amongst first timers. We'll then talk about the difference between registered and unregistered trademarks. And that obviously leads into why should you register your trademark. We'll then discuss things for you to think about when you're developing a trademark. And then I'll finish off with a brief overview of what the registration process looks like. So let's start with what is a trademark. It probably seems a little basic to start with this question, given that I'm sure you all have a pretty good idea what a trademark is. However, it is useful to understand the key elements of a trademark, as they will come up again and again through this presentation. So on the screen here are just a few definitions of a trademark that I found online. And if you look through those, you'll see there's kind of some consistent points. They refer to it's a type of intellectual property. They refer to it being either a sign or an insignia, a word or a symbol. And then the other consistent part is that it's used to identify a product or service, that a product or service comes from a particular source. But here's how a trademark is actually defined in the Australian Trademarks Act. It's pretty simple, really. Trademark is a sign that is used or intended to be used. Intended to be used is a key element here. A sign used or intended to be used to distinguish goods or services dealt with or provided in the course of trade by a person from the goods or services so dealt with or provided by any other person. So pretty simple definition really, but you'll see that the first thing is a trademark is a sign, which poses the question, well, what is a sign? And the Trademark Act defines a sign as including again being the operative word, any letter, word, name, signature, numeral, device, brand, label, ticket, aspect of packaging, shape, color, sound, or scent. So I'm not sure whether there's anything in there that would be particularly surprising. Maybe the sound or scent, that they are fairly recent additions to the Trademarks Act. But it is really important to note that this definition is not exhaustive. What can qualify and constitute a trademark is open. And so since the current, still referred to the 1995 Act as the current Act, since the 95 Act came into effect, we've now seen trademarks in relation to things like holograms, movement, taste and feel. Should be noted that whilst all of these things are available, they're not some of those more peculiar things like a scent or a feel, not easy to obtain registration, but not impossible. So really the sky's the limit in terms of what can actually be a trademark. So let's have a look at the usual types of trademarks. These are all registered marks on the trademark register. As you might expect, there's plain words like Telstra. There's slogans like "Let your fingers do the walking," and "Let your fingers do the walking." When I used to do this presentation, was something that was very obvious. Now we don't use yellow pages like we used to, but I'm sure everyone is probably of a vintage that remembers that slogan. Obviously, we've got stylized words like the Coca-Cola symbol there. That's the original Coca-Cola logo that's been registered in Australia since 1920. We have logos like the Qantas logo. Got a couple of shape marks here. Everyone, I expect, will recognise this one in the middle here as the Weber barbecue. And there's also the iconic Coke bottle called the Contour bottle. Color, sorry, color is also registrable, difficult, but not impossible. And Cadbury has managed to trademark the color purple. This one here with the man with the outstretched arms is actually a movement trademark. That's from Toyota. That's the leaping at the end of all of their ads with the oh what a feeling, where all those people look like idiots as they jump in the air. That's a registered trademark for Toyota. This one here, which is obviously very difficult to see, but that's musical notation. Unless there's anyone that's extremely gifted, you probably won't know what that is. But that is the introductory theme for 20th Century Fox movies, which everyone I'm sure is familiar with. And another interesting sound mark is this one down in the corner, McCain, ping, you've done it again. That was one of the first sound marks actually registered in Australia. So it just gives you an idea of how broad it can be. Scent marks, there are currently only 2 scent marks on the Australian Register. None of them are for perfume, because you can imagine everyone trying to, trademark the scent of a rose for or something like that for a perfume. That's extremely difficult. The 2 scent trademarks are really quite bizarre in my opinion. One of them is in respect of golf tees, the little wooden tee that the ball gets put onto, the scent of eucalyptus for those, and there's also a registration for the smell of cinnamon for plastic furniture. So there you go. Yeah, I can see a few bewildered looks on faces, and I understand why. But it just gives you, and also there's the SO one there, which is the combination of the words and the colour on the Bowser and the service station. So pretty broad spectrum. What's the last one I haven't mentioned? The Apple iPad box. That's actually the packaging itself, which is the box plus the image of the iPad. So as I said, what can be a trademark is as broad as your imagination, really. So before we go any further, I just want to cover off a couple of really key concepts to bear in mind. As we sort of touched upon in talking through the definitions, trademark is a sign that's used to distinguish the goods and services of one trader from the similar goods or services of another trader. That's the key, the key purpose of a trademark. Ownership, another key concept. In Australia, the ownership of a trademark is the first person to use the mark in trade, or the first person to file an application for registration with the intention to use it, whichever is earliest. So let's just go over that again. First person to use. So if you are using an unregistered mark, you are the owner, even though you haven't taken the steps to seek registration. First person to use, or if you haven't used, but you have filed an application, the first person to file the application with the intention to use, the earlier of those 2 is the owner of the mark. Okay, so you'll see why that's important as we go on. And again, as I touched upon in the introduction, trademarks can be registered or unregistered, but a business name registration is not enough, of which I have there in red letters because it's important. So let's talk about that. So a common mistake that I often see amongst small business owners is this misconception that, hey, I've registered my business name, so therefore I'm protected. Now, the heading on this slide talks about a business name registration. It can equally apply to company names. So some of you may have registered companies with ASIC, and some of you may be sole traders that have instead registered just a business name. These concepts are the same in terms of this point about neither a company name or a business name actually protects the trademark. So if you have a registered company name, the company name itself actually only serves to identify a legal entity. But that's the sole purpose of the company name registration, identifying who the legal entity is. If you've got a registered company, the company actually takes on legal personality, i.e. it can be sued. A business name registration, if you have a business name registration, that's actually a legal requirement in Australia. If you operate a business under a name that is not your company name or your personal name. So if you're a sole trader and you're not just operating under your own personal name, but you're instead operating under some other trading name, it's a legal requirement to register that business name. And the reason that that exists is so that consumers can identify the operator of the business. So if I'm engaged in trade with a sole trader who's operating under a business name, and I have a complaint about the product, how do I identify who it is that I need to chase? So that's the purpose of the business name registration itself. But neither a registered company name or a business name registration actually confer a proprietary right in that name. The mere fact that the company or the business name is registered will not of itself be sufficient to prevent a third party from using the same or similar name in respect of their own similar goods or services. In fact, despite registering your company name or your business name, you could be compelled to change your name if its use as a trademark would actually constitute an infringement of a third party's trademark rights. So when you go to register your company name or your business name, ASIC is not conducting a market search and it's not conducting a search of the trademark register. It is only looking at the business name register or the company name register to determine whether that mark is too similar to an existing name. It's not concerned with what's in the market or on the register, which means that even though ASIC might give you the big tick that your name is okay for registration, you could be wading into problems if you infringe someone else's trademark rights. So let's talk about unregistered and registered marks. We'll start with unregistered marks because everyone's probably got unregistered marks. Once you start to use your trademark, and so we're not talking about trademark here, I'm talking generally, that may be your business name, it may be the name of products or services that you provide if you've got specific names for those. But once you start to use any of those trademarks, you begin to accrue reputational or what's known as common law rights. So that happens automatically. You start to build that reputation, you start to build common law rights in your unregistered trademark. But if you need to then try to enforce your common law rights against someone who's infringing upon your rights, your options are the common law tort of passing off. So that's when the infringer is passing off their goods or services as being yours. That usually means someone's actually acting in an underhanded way where they're trying to suggest that your goods or services are theirs. So that's relying on passing off, or relying on the misleading and deceptive conduct provisions of the Australian consumer law. This is the equivalent of the old trade practices law for those of you who have been operating under that act in the past. But the Australian consumer law prohibits anyone engaging in misleading deceptive conduct. So usually that would take the form that the infringer is engaged in misleading or deceptive conduct by misrepresenting to consumers that its goods or services are connected to, affiliated with, or endorsed by you or your company. So the difference between those two, they're very similar in concept, but passing off is really set up to protect you, the trader, whereas the misleading and deceptive conduct provisions of the Australian consumer law are really set up to protect the consumer. Despite the fact that they protect the consumer, you as the trader can still rely on that law to enforce your common law rights. So what are the advantages of using unregistered trademarks? So the first one is, to some extent, it's cost effective because you don't have to pay anything to create it. You're already operating your business, you're already doing your advertising, your trading, and each time as you do that and build your business, you're building those common law rights. So there's been no cost per se for the trademark by doing that. There's also, so apart from the cost of registration, there's no need for periodic renewal because your reputation will exist as long as you continue to trade. The other advantage of unregistered trademarks is their flexibility. That is because as your product offering expands, as your business expands, there's no need to expand the scope or update the scope of a registered trademark, because as your reputation expands, your reputation expands as you expand. So that just happens in a fluid way. Of course, there are disadvantages. And the number one disadvantage of an unregistered trademark is the difficulty of enforcement. So I have just explained you do have the ability to rely on passing off and misleading and deceptive conduct to try to enforce. But to enforce, to use either of those modes of enforcement, you first need to demonstrate that your trademark has acquired a reputation in Australia. You think about the concepts behind passing off and misleading deceptive conduct are both confusion. So if no one's ever heard of your brand, they can't be confused if they then see someone else using a similar mark. So before you can even start on trying to enforce, you need to be able to demonstrate that you've acquired a reputation in Australia. Now, that can be expensive to demonstrate because to do that before the court, you need to spend money filing lots of evidence to demonstrate your reputation and also to establish your ownership. And apart from being expensive, it can be difficult to demonstrate a reputation if your use has only been limited either by duration or by geographic reach. So for many of you, you may only be operating locally at the moment. And so what does that mean if someone infringes your rights somewhere else in Australia? If your reputation doesn't extend across the country, then there's no passing off and there's no confusion in another jurisdiction. So that difficulty in enforcement is a key disadvantage of relying on unregistered marks. It's also impossible to license an unregistered trademark. So some of you may sell goods under a particular trademark, where someone may like to license that to also sell the same goods. That can create a revenue stream without licensing. But if you have an unregistered mark, it's impossible to license. And the other big disadvantage of relying on unregistered marks is that you can only assign or sell your trademark along with the goodwill of the business. So it's inextricably tied to your business. If you want to sell your mark, you've got to sell everything. So that leads us across to registered marks. And the key advantages of registering your marks. Now, there are many advantages, but the number one advantage is the first one there. If you secure registration, it provides the statutory exclusive right to use the trademark in respect of the goods and or services for which it's registered. So you get to put a fence around your goods and services and have the exclusive right to use the same mark or something deceptively similar to it. So that's extremely powerful in terms of building market advantage. Another advantage of registered trademarks is that you can apply for and you can secure registration with only an intention to use. You remember I mentioned the importance of that earlier on in the definition. So you can secure a registered trademark without ever having used your trademark. So as long as you have an intention to use, let's say you're talking about you develop a new product in your range or a new service. I'm going to roll this out, but I'm not ready to roll it out yet, but I'm going to file a trademark and try to secure my position. You can actually secure a registered position before having used the mark, and then you can enforce against third parties for infringing that mark, even though you haven't even used it yet. So there's no need for you to demonstrate that you've got a reputation. The trademark registration is enough. Again, extremely powerful. A registered trademark is also a business asset. It's actually an asset. It can be valuable in its own right, and it can add value to your business. For a lot of you, business model may be, the plan may be to build your business to a point where it's attractive for someone else to come and buy your business. Well, having the asset of the trademark registration can add considerably to that position. And it also is a piece of personal property. So at law, it's considered personal property. You can sell it, you can license it, you can will it. So that what you can do with it is there's far more flexibility compared to an unregistered mark. Further advantages, as I said, much easier to enforce. No need to demonstrate that a reputation has been acquired. It also provides the ability to legally deter others from using your mark. So what does that look like? It means things like the presence on the trademark register acts as a deterrent right then and there, because people will look at the trademark register when they're considering developing their own mark, and if they see yours, then they know that that's taken. There's deterrent right there. There's also the deterrent factor of being able to use the R symbol. Everyone's will be very familiar with the R symbol. They've seen it a million times. That can only be used when you have a registered trademark, and you put that on your product next to your trademark. That acts as a deterrent as well. People know that if they use that, then they're going to be infringing that registered position. And another advantage of registered trademarks is for those of you that are selling products, you have the ability to lodge a notice with the Australian Border Force for the purpose of them identifying and seizing counterfeit products. So that's a free service that's provided by the Australian Border Force, where if you have a registered trademark, you can lodge a notice notifying Border Force of your registrations, and they'll keep an eye on goods as they come into the country, and if they consider those to be infringing goods, they can seize those at the border rather than you having to deal with infringing product in the market. So that's a very valuable and powerful tool. So what are the disadvantages? There are some costs. I would say, obviously, as a trademark attorney, I'm probably biased, but I would say in the big scheme of things, the cost of securing trademark registration is relatively low. It's not a huge cost, particularly in Australia. But there are costs. So there's costs in going through the application process and also in renewing your trademark to keep it alive. Trademarks, once they're registered, they're alive for 10 years, but you can continue to renew them for periods of 10 years. So yes, there are costs. It is, sorry, I saw that there was, it's not yearly, it's every 10 years. Also, compared to the unregistered marks, they're inflexible, and what I mean by that is once your mark is registered, you can't change the you can't change the mark in the registration, and you can't add goods or services. So as your product range expands, you would need to file a new application to cover those new products. But that's something that when you file an application, when you work with your attorney, you'd be actually looking to file for a fairly broad protection at the start to try to cover off things that you might be moving into, so that you don't have to file an application every time you add one single product. You try to sort of file a little bit more broadly to sort of avoid that issue. Okay, so now let's talk about developing new marks. And as I said before, this is not just about your company or business name. This is talking about products and services in your range. So clearly there are a large number of factors to consider when choosing a name or a brand for your business or your products, including your value proposition, your target audience, and your position in the market. This may be stuff that Transcend looks at in other parts of its training. I'm not here to sort of give you marketing advice about those things, but there's a lot of things to consider. But what I would like you to consider, and what is important, is two critical questions. And the two critical questions, I hope, are probably a little bit more evident given the stuff that we've already covered. So we've got, firstly, is the trademark capable of distinguishing your goods or services from those of another trader? We know now that that is the primary purpose of the trademark. So when you're asking that question, is it capable of distinguishing, that needs to be considered in the context of your goods and services. So the example I've given there is, if you were trying to secure a trademark registration for the word apple and you were selling apples, that's not going to be capable of distinguishing, because every other person that sells apples needs to use that word as well. I mean, apart from the fact that it won't distinguish you for the purposes of the Trademarks Act, it's not going to distinguish you in the market anyway. So the kind of things that where you'd be thinking about setting yourself apart from your competitors is the kind of thing to be thinking about here anyway. So Apple would not be capable of distinguishing in respect of fruits, but Apple is clearly capable of distinguishing in respect of computer hardware, because Apple says nothing about computer hardware itself. The only reason we put those two together now is because we're all familiar with the Apple brand. But when Apple first filed, Apple would have, even though Apple is a known, common English word, it is capable of distinguishing in respect of computer hardware because it says nothing about the computer hardware. It's a completely random word in respect of computer hardware. And the other important thing to consider, and in my view, the number one thing to consider, is the mark that you're considering too similar to any other existing trademark in respect of similar goods or services? The number one thing, in my view, is avoiding infringing someone else's rights. So when you're considering that, you need to consider both registered and unregistered trademarks. So trademark searching is critical. Looking at the trademark register for registered marks is critical, but also looking at unregistered marks. So there you're looking at company names, business names, because they may give you a clue that someone else has unregistered marks. So you're not going to infringe, as we said earlier, you're not going to infringe the business name per se, but if that person is actually operating their business, they may have started to build common law rights. So looking at the company names and the business names is a great first start. Looking at things like the telephone books, general internet searching, domain names, social media, all that type of thing. That's the type of thing where I would definitely recommend the assistance of a trademark attorney who's trained in doing that, particularly for the looking at the trademark register. And hopefully shortly you'll see why I recommend that. Why do I say that avoiding the infringement is the number one priority? Because infringing can be very, very costly. It can be costly in terms of the legal costs that you have that you incur when you're dealing with the infringement. There's also possible payment of damages or an account of profits to the person who that you've infringed. That can obviously be very costly. There's also the possible costs involved in having to doing a rebrand. And there's also the possibility of reputational damage if it's public that you've infringed a third party. So those are the things that I would really like you to have in mind, apart from all of the marketing stuff. So that I understand there's a lot of stuff to think about, and it's not easy. Certainly, I have a lot of people come to me saying, "This is the one that I've chosen," and sometimes that's sorry, I think it's back to the drawing board. But in my view, as frustrating as that is, much better to have that answer and know that you're not going to infringe, and then spend the money and then find out the hard way. So now I'm going to talk about, I've extolled the virtues of registered trademarks. So now, how do you go about actually securing registered marks? So I'm going to talk very briefly about the application process. Trademark applications are filed with IP Australia. IP Australia is the body that administers IP rights such as trademarks, patents, designs, and plant breeders' rights in Australia. IP Australia is based in Canberra. And so the trademarks are filed online through the IP Australia platform. Starting point to consider when filing an application, and this is going to sound pretty obvious, but think about what's the trademark to be filed. Now I say that's obvious, but if I just talk about this Frankston Business Collective example on the screen, there's probably 3 possible trademarks right here. So you've got the combination of all of those elements that you see right there on the screen. That's one possible mark. There's the possibility of just filing an application for the FBC component on its own, and there's also a trademark there for the Frankston Business Collective words on their own. So why would you file for one or the other or all of them? It's because the protection they provide all differs. So a trademark registration for the plain words Frankston Business Collective, that would provide protection for the use of those words in any color, any font, any style. So that's the broadest protection that you can get. Filing for the FBC component, just that component on its own, will probably provide protection against people using FBC in different styles, probably. And it will probably also protect you from anyone using maybe 3 other letters, but in the same orientation with the white line through it like that. So it gives you protection more around the look of that logo. And the combination gives you protection around the use of words in the stacked form against the similar logo. So the type of protection that you get from the different types of marks is different. And again, that's something that advice from an attorney would be able to step you through that. Obviously, there's the more applications you file, the more costly. So there's always a cost question, but your attorney will be able to talk about, well, what's the most important stuff here? How are you planning to use the mark? Where are we going to get the most bang for your buck? So considering the applications to be filed, number 1. The next thing is considering who's the appropriate applicant. Again, probably sounds pretty obvious, but it's really important to identify the correct applicant when you file a trademark application. Important because if you get it wrong at the start, your rights, any rights that you might secure at the end could be invalid if you've got it wrong. So the owner of the mark, if you have a registered company and you're operating your business as a company and the company is controlling your mark, then it's probably the company that should be the owner. If you are a sole trader that operates just under a registered business name, it's fine to register just in your own name. Really, the question is who is going to be controlling. So where there can be traps is where you've got a person that has a registered company who files in their own name, despite the fact that it's actually the company that's using. Now, the fact that you might be the sole director of that company, it doesn't help. The company itself is actually the legal entity that's controlling the use. So careful consideration of who is the owner is important. And then the third dot point there I've got is considering the scope of the protection required. So when you file an application, you don't just get protection for everything. You've got to state what are the goods and or services for which you require protection. Now, goods and services are separated into 45 separate classes under a thing called the NICE classification, which is used nearly in nearly every country around the world. Again, your attorney can help you with trying to figure out what are the classes that you need to file. And as I said before, that's a consideration of not only what do you do now, but what are the areas that you're likely to move into to try to cover that stuff at the start so that you don't have to keep on filing your applications as your products expand. Okay, so that's the application itself. I should just say with the scope of the protection in the classes, the number of classes that you have in your application determines the costs of your application, and that's whether you file the application yourself or whether you use an attorney, because there are official fees that are paid to IP Australia on a per class basis, and if you're using an attorney, their charges will also be on a per class basis. Okay, so once the application gets filed, you'll get a filing receipt, which will just give you an application number. And then in Australia, at the moment, the application will sit there for about 2 to 4 months while it's awaiting examination. But the important thing to bear in mind is once you've filed the application, that's your starting point. You've put your official flag in the ground at the date of filing. So examination in around about 2 to 4 months. By world standards, that's probably pretty quick. If you file an application in New Zealand, it might be maybe about a month. If you file an application in Bangladesh, it might be 10 years. So the length of the examination is kind of determined by how busy the register is and how electronically advanced the office is. Okay, so examination. There are two main issues that are considered during the examination, and again, you'll see consistent themes about what we've talked about. The number one thing is, remember, what's the whole purpose of the trademark? It's to be able to distinguish one trademark from the goods of one trader from those of another trader. So the first thing that's considered during examination is distinctiveness. Is the trademark inherently capable of distinguishing the claimed goods or services from the similar goods or services of another trader? You see, I'm just repeating myself now. So the question is, does the trademark consist of a sign that other traders, actuated by proper motive, so that's someone that's not looking to rip you off, not someone that's acting in bad faith, someone that is acting in good faith, what's the likelihood that they would want to use this mark in respect of their own goods or services? So come back to my example of Apple. Everyone that sells Apple would want to use the word Apple. So what's the likelihood that someone who is acting in good faith would want to use this mark in respect of their goods and services? So is the mark descriptive? If I try to register the trademark mug and I'm selling coffee mugs, everyone's going to want to do that. It's not going to distinguish. Apart from anything else, it's not going to be a very smart business thing for me to be trying to use that as my brand, because I'm not going to distinguish myself from anyone else in the market anyway. So is it descriptive? Is the mark laudatory? So if my trademark is great coffee mugs, again, other traders are legitimately going to want to be able to use that word in respect of their coffee mugs. So laudatory marks, very difficult. Not impossible. I know an example, for example, fantastic furniture. But the way that fantastic furniture and other people that have distinctiveness issues can overcome that objection is by providing evidence of how much they've used the mark, where they can demonstrate that people actually now recognize fantastic furniture as being a brand. It's not just a description, but that's something that takes a lot of time. And obviously there's more cost involved in doing that. So if you're starting, if you're developing a mark, you're trying to avoid having to do that. Does the mark indicate the geographic origin of the goods? Place names can be difficult because everyone legitimately from that place would legitimately want to use the same name. So geographic names can be very difficult. Again, not impossible, but difficult. And does the mark consist of a common surname? So if I'm going off as a Williams, it's, I think, the third most common surname in Australia. That's going to be difficult for me to be relying on Williams as being able to distinguish my goods from someone else. It used to be the Australian Office used to use the arbitrary number of 750 times on the electoral roll as to whether a name was common. So the bar is pretty low as to what they consider is a common name. There's something like 60,000 Williams on the electoral roll. But distinctiveness is the first thing they're looking at. Here's some examples. These are real examples from trademark office decisions from 2023 of marks that were not considered capable of distinguishing. Defence jobs for recruitment of candidates, because it described the type of job. This is going to be a job in the Defence Force or of some kind of defence nature. So that means anyone that's going to be recruiting in that for defence jobs is legitimately going to want to use those words. Some of these get a little bit more black, not black and white, and into grey area. For example, one that I thought was very interesting was Australian Monsters of Rock for promotion of entertainment events. Now, I would have thought on my first reading of that, Monsters of Rock, the use of word monsters would be something enough to make that distinctive. But when I read through the decision, it said that in respect of rock and roll events and that type of thing, that monsters was commonly used to as a description for in entertainment, which I thought was interesting. You might find the bottom one interesting. The logo, slight logo or slight stylization of the word red was not enough for digital still cameras, and that was considered descriptive simply because the cameras could be red. So the types of marks that have been not capable of distinguishing. Now, the other main issue considered during examination is prior marks. So again, come back to what's the core thing of the trademark: capable of distinguishing your goods from the similar goods of other traders. So that means the trademark examiners will also look at what is on the register. So it's important to note here that the examiner is only concerned with registered marks or applied for marks that are on the trademark register. They are not concerned with what's in the market. They are not looking at unregistered marks. It's important for a couple of reasons. It's important because in some ways you might think, well, that narrows the field. Then it means I don't have to worry about those unregistered marks. Well, those unregistered marks may not be an obstacle to you registering your mark, but they may still be an obstacle to you using, because you, as we've talked about before, you can still infringe an unregistered mark. So just because a trademark examiner comes back and says, no, there's no prior marks, doesn't mean that you don't have to consider the unregistered marks in the market. Hopefully I've really hammered that point home for everyone. Okay, so let's look at this question. Is the trademark substantially identical with or deceptively similar? Deceptively similar here is key to another mark on the register in respect of similar goods or closely related services. So you can see this is a two-pronged question. There's firstly the comparison of the marks, substantially identical or deceptively similar, and there's also a comparison of the goods and the services. Okay, so substantial identity is usually pretty easy to consider, because that's a straight side-by-side comparison of the trademarks. So for example, super cool in capital letters as one word is going to be substantially identical to that super cool. Sounds the same and pretty much looks the same. Deceptively similar gets far more grey area. Does the mark so nearly resemble the earlier mark that it's likely to deceive or cause confusion? So this question here is not a straight side-by-side comparison. The comparison is, the examiner is looking at it in terms of, if a consumer is familiar with, is aware of one mark and has that idea in their head, and then sometime later they are confronted with this mark, are they going to be confused? They've got to consider the effect or the impression that's produced on the minds of the consumers. They'll consider the look and the sound of the mark. They'll also allow for the fact that consumers don't have photographic memories, so they'll allow for what is called an imperfect recollection. So what is it about the earlier mark that I'm familiar with? What are the key elements of that I remember? When I see this one, do I now think it's the same, or do I think it must be related? It's some way connected. What's the impression that I have in my mind? So you can probably tell that really does throw open grey area. So that's the comparison of the marks. The other part of the test is considering, does the mark cover similar goods or closely related services? So when the examiner is looking at that question, they're considering what's the nature of the goods, what are the uses of the goods, what are their trade channels. There's a number of things that are considered. So let's have a look at some examples. Again, these are from real decisions from 2023 of marks that were considered deceptively similar. So in all of these cases, the mark on the left was the mark that was just applied for, that was blocked by the mark on the right. So here, despite the fact that at first glance you can see these marks are quite different, the key part here is with the spoken word O'Brien is the same in both. Boiler services in respect, so both of these marks covered plumbing. The words boiler services, whilst they don't appear in the first mark, they're just descriptive words. So anyone that was thinking back to this, they would just think, well, boiler services, okay, it's plumbing. If I see this O'Brien in respect of plumbing, do I think it must be the same brand? Is it just a rebrand? So deceptively similar. To me, as a trademark attorney, that one for me was pretty obvious. Some of them get a little bit more obscure. Society cycling and society gear with a logo, both in respect of clothing. Now, clearly in this one, society is the key component. It's the big word. And here the society is only small. But I get the impression that the examiner has said, well, gear in respect of clothing is actually a descriptive word. They're not intending for gear to be the primary, the primary indicator of trade source here. Society is really the word that gives this, identifies the trade source, and therefore deceptively similar. Of course, this one's got the word cycling, but in respect of cycling clothing, that again is only a descriptive word. So that one, is a little bit more on the fence, I think. This Revel training and this logo. So again, this one's got words and this one's got nothing. But if I'm familiar with this logo in respect of, I think this one was the gym and fitness facilities, and later on I see this one in respect of exercise services, do I just recall that, oh yeah, that's the triangle mark that I've seen before. This must be their name. That's where the confusion is possible. And then this one, Acorns Grow and Acorn Capital. This is a bit of a touchy subject for me because I was on the losing side of this one at my old firm, where we were trying, I was acting for Acorn Capital, and I was saying, I was acting for Acorns Grow and saying that wasn't deceptively similar to Acorn Capital. But I went down in a huge ball of flames. Last couple, Eleve and Elvive. I think that's an interesting one because they don't sound the same, but they probably do have some visual similarity. And there are also considerations here is looking at the goods. Are these the types of things that people would order verbally? You probably wouldn't go in and buy a perfume or a shampoo by asking over the counter. You're probably grabbing it off the shelf, which makes the visual aspect far more relevant. If it was something like cigarettes where you now have to ask for it over the counter, the spoken word would be far more relevant. Also in the consideration, the expense of the goods is relevant, because if I'm talking about a packet of chewing gum that's going to cost me $2, I'm probably, or a can of soft drink where I'm just grabbing it out of the fridge for $3. That's different to the type of inspection that I would give to the goods if I was buying a piece of machinery, for example, where I'm going to be giving that a careful inspection, where I'm far more likely to pay attention to the trademark. That last one there, I think, is an interesting one. United Food Express considered deceptively similar to United Rewards card. And that even the goods there are interesting. That was import services against retailing services. But I use these to highlight that when you're doing some searching, if you are about to develop a mark, it's important to realize you're not just looking for the exact mark. So obviously, if you find the exact mark, that's important. That's going to tell you there's an obstacle. But you've got to look more broadly than that. And this is where a trademark attorney can really assist, because they've got, one, the ability to set up the search to be able to find the types of things that are more likely to be captured. And then two, they've also got a better feel for what's the current process within the trademarks office. The examiners seem to go through phases of what they consider close and what they don't consider close. Okay, so now the final part here is, what does the actual process look like? I'll run through this very quickly. So we've filed the application, we've talked about the examination process. So what happens when they go through the examination? If there are grounds for rejecting the application, so if they find a prior mark that's too close, or if they consider that your mark is not distinctive, what happens? You don't just get a flat rejection. It's not the end of the game. What they'll do is they'll issue a report where they'll detail the nature of the objection. And then you've got 15 months, which you can extend by up to 6 months if you pay fees. You've got 15 months to overcome those objections. And how you overcome the objections will depend on what the type of objection is. So, for example, if there is a prior mark that gets cited against you as a block, how might you overcome that? There's any number of ways. You could try to argue that the marks aren't similar. You could try to argue that the goods and services aren't similar. You could possibly remove goods out of your application to avoid the conflict in the goods. I said before, you can't add stuff in, but you can take stuff out. So you can make it more narrow. If none of those options are available, you can potentially negotiate with the owner of the site of mark for them to consent to your registration. If the trademark that's blocking you is not in use, there's methods to be able to try to take that mark off the register, a process to go through to try to have that removed for not being used. There's any number of ways that you can try to overcome those. But again, that's where someone like me comes in to take you through that path. Once those objections are overcome, or hopefully if no objections are even raised, the application gets accepted for registration. Now, at that point, the acceptance gets advertised in the official Journal of Trademarks, which is a really great read if you've got insomnia. But think about the acceptance in the journal at something like if you were to apply for a planning permit for an extension on your house, that gets approved. It then has to get advertised, and it's to give third parties opportunity to object. So in Australia, once your trademark application is accepted and advertised, there is a 2-month window for anyone who wishes to oppose the registration. Currently in Australia, about 3% of applications get opposed. And if there is an opposition, then there's a whole process. That's kind of like how you might think a litigation would happen, but it's not in the courts. It's within IP Australia, so it's far less expensive. But we won't go through that opposition process. As I said, only about 3% of cases. If there is no opposition, then your application proceeds to registration and your registration certificate issues. And that's the key date. Once you've got that registration, that's what you're looking for. You then have your enforceable right. You then have your legal personal right. And your rights will date all the way back to the date that you filed the application. So the date that you file the application is important. Is why the earlier you can get it filed, the better, because that's the date that your rights are going to come back to. The registration certificate, Australia used to issue a nice certificate with a ribbon and all that. Now it's just it's a crappy PDF document. So that's a bit disappointing. You can pay extra fees to get a nice certificate for your wall, but really the value is in what you can do with it. Some key resources for you to all keep in mind. The IP Australia website, I'm sure you've all probably been there before, but the IP Australia website's got a lot of great resource information. This one here, Atmos, I encourage you all to have a look at this website. Atmos is the Australian Trademark Office search system. This is the searchable Australian Trademark Register. So it's a pretty easy system to use, and I certainly encourage you all to have a play around and do some searching on that. Global brand database gives you a snapshot of a lot of the marks that are registered overseas. It's not everything, but it gives you a look at what's registered overseas. And of course, our James and Wells, our website has a lot of information as well. So that's it. That's the information that I wanted to go through. Let's just hammer home the takeaways. Registered business name of itself does not protect your brand. Surely I've smacked everyone in the head with that point enough. Registering your trademark provides a multitude of advantages. Ensuring your trademark does not infringe third-party rights is critical. Can't hammer that point home enough. Don't infringe someone else. It's just costly. It's avoidable. It is avoidable. A good trademark should be able to distinguish your goods from the similar goods of other traders, not just so you can register, but so you can stand out from your competitors. It just makes sense on all fronts. You should consider registering trademarks not only for your business name, but for your key products and services. It's not just about your business name. Think about the way that you can leverage your trademark to provide value to your business. So think about licensing, that type of thing. Enforce your rights. It's your brand. You've developed your brand. You've spent your money developing your business. If you've spent the money registering the mark, enforce it. Guard it preciously. Keep an eye on what people are doing. And if they encroach, you enforce your rights. And of course, the final thing is a good trademark attorney is worth their weight in gold. If you need one, I can see if I can recommend one to you. No. That's what I wanted to cover. I did see some questions popping up. I'm happy to sort of go through those. Happy to go through those now.
Linda, you were first with a couple of questions. Are they still questions in your mind?
Yeah, they are. Thanks, Rod. So I really love the example, Mark, that you gave of the Toyota movement. And I'm curious as to, for something as sort of iconic as that, how much variation does there need to be for it to be classified as within the scope of that trademark? Because even when you see the Toyota ads, everyone's jumping at different heights, their legs are in different places, their arms are all over the place. How is that trademarkable?
So it's a great question. One, how is it trademarkable? I'm going to answer it in reverse. How is it trademarkable? Difficult. That would have been lots and lots of evidence of use. But the scope of the trademark won't just be the exact image of that man that we saw in the mark. There'll be what's known as an endorsement, which is basically a description of what the scope of the protection is. And I'm sure it will read something about doing that at the end of the Toyota. Oh, what a feeling jump. So it's not the actual shape of the jump, it's the placement of it within the phrase. Okay, so it's a great question. The other thing is, and this is not just about movement, but it's about all trademarks, is the question is, for a mark to infringe, it has to be something that is deceptively similar. And as we talked about, so it's not just did they use the exact mark, did they use the mark or something that's deceptively similar, which is where all of those other considerations, what is it that I remember about the first mark, and when I see it from the later one, what are the key things that I consider? Am I caused to wonder whether they've come from the same source? So it's a great question.
Makes sense. Okay, the other one I had is Telstra rebrand. In my lifetime, they've done it about 1,000 times, and there's huge variation, color changes, font changes, logo changes. Again, in every iteration of that, do they need to trademark?
Yes.
That's where all our taxpayer dollars were going, people.
That's the short answer. Well, that's probably the long answer as well. So with the the ability to change a trademark once it is registered is extremely limited. The only changes that you can make to a registered trademark, as I said, you can't add goods in or goods or services in, that is impossible. You can't expand the scope of the protection. And the only change to the mark that you can make is a change that doesn't substantially affect its identity. So again, that's a grey question, but that's got to be something that's only very minor. So if it was just a slight change in font, for example, or I'm trying to think of an example that I've done myself. I used to do work for the Victorian Department of Health, and who run the Better Health channel, which is, I think, it still runs. And the Better Health channel used to have the little logo of an apple on top of it. And again, our tax dollars at work, for some reason down the track, they changed their logo, that it was still Better Health channel with an apple, but the apple changed. And so rather than filing an application, I sought to amend that one, saying it hasn't substantially affected the identity. Yes, the apple is different, but the words are the same. The concept is the same. It's still an apple in the same place, and we were able to amend. But it's got to be a pretty minor amendment for you to be able to do that. So for Telstra, from changing from Telecom to Telstra, from logo to logo, new applications every time.
Okay, thank you very much. I see there's Jude and Sina also had some questions as well.
Yep, thank you, Mark, for a informative presentation. Question: as a startup business, if we decide to defer registering the process, I'll come back to the cost question later. You did mention under the common law, when we start using the trademark, the logo, you're automatically covered. But what do we need to retain in the court of law to prove that when we started to use, and how do we prove that?
Yep, great question. So you're right. As soon as you start to use, you start to accrue common law rights. It doesn't mean that from the day that you start that you have got rights at that point, because remember, the rights all rely on reputation. So I may have started my business yesterday. I've probably got zero reputation today. So yes, I've started to build reputation, but I wouldn't have enough to be able to then go and enforce against someone. So keeping records of all the types of uses that you make. So that's demonstrating the types of uses that you make and having samples. We're talking about sales data. We're talking about advertising revenue. So apart from samples of your advertising, samples of all of your promotional materials, samples of any brochures or documents that you use, keeping samples of your past website, that's an important thing. Now, for those of you that haven't done that, I certainly recommend using, for anyone that hasn't used it, the Wayback Machine. People familiar with the Wayback Machine? It's archive.org. It's a free service. Archive.org allows you to go and have a look at archived internet pages. So you can get a snapshot of what a website looked like at a certain time. So being able to show, this is the use that I've made over time. Here are samples of the use, but here is the geographic reach that I've got. Because remember, you're trying to demonstrate reputation. What is people's awareness of you? It's not enough that you can say, here, I've got 1 million documents that have got my brand on it, if the 1 million documents have never been distributed to anyone. So you've got to be able to demonstrate. So it's all about your record keeping, which is one of the advantages of the trademark registration, that if you've got a trademark registration, you don't need to demonstrate any of that because you've got your registration certificate. It should be noted that when you come to enforce, nearly all the time, we're using both of those tools. We're using the trademark registration, but we're also talking about misleading and deceptive conduct. We would try to, it's the scattergun approach. You try to fire off as many bullets as you can and see which hits. So that's one of the key advantages of the registration, is you don't need to have all that process of showing your reputation. But it's also a good reason, there's also another reason to keep those records, because if down the track when you decide I am going to now try to file an application, depending on, you might get an objection that requires you to go back and show, well, this is the use that I've made, and I've got all of that material.
Thank you. Second one, I'm not sure this is the right forum. Roughly, what would be the cost? I know it depends on how many different classification. What would be the basic cost? So we don't have to worry about it. Can proceed with the.
Well, obviously, there's different costs. You know, if you file yourself, there's at IP Australia, the only costs that you would be filing then are the official fees that are payable. And the official fees change a little bit depending on what descriptions you use, but as a general rule, $400 per class is your official fee. Obviously, if you use an attorney like me, then I'm going to charge you as well. I'm not a free service, but obviously there's the value of using the attorney in getting the application right and then taking you through the process.
Yep, perfect. Thank you.
And the other thing to consider is the cost of searching. So as I said, important is doing the searching. Searching, there's no obligation to do that. It's just good practice. It's good practice. I always recommend people to do their own searching first, particularly in respect of what's out in the market. You guys are the experts in your field, not us. So you've got a better feel, should have a better feel for where to be looking for competitors and what they're doing. And certainly I recommend using the Trademark Office search engine to be looking at stuff. But because we've got to look at deceptively similar, that's where it gets more difficult. And so a trademark, come back to the cost question, for me to do a trademark search is usually, it will depend on how extensive your goods and services are, because the more extensive your goods and services, the more trademarks that you run into. But you're usually looking somewhere around about $1,500. So it's not, I know all of those expenses are big for a small business, but when you consider the ultimate value and the risk avoidance, it's actually a pretty good, it's pretty good costs.
Yep, makes perfect sense. Thank you. Thanks, Mark.
So, Sina, you had a question? You still got the question?
Yeah, hi. So I was comparing the registered with I've just got mine.
Sina, you're dropping in and out. So what you're saying is garbled. Are you able to write that into the chat? And we'll try and answer the question.
And you're frozen as well.
Yeah. While I've got everybody, you know, an example which was a bit of an eye opener to Jamie and I was a small business we started working with about 2 months ago. I won't give you their name, but let's call it ABC. And they built their online clothing business up to be quite a good turnover / profitable business. And then all of a sudden they got a legal letter from an organization called ABC. They were both in the clothing industry, different types of clothing, but they decided to change their name and not push back. But that had a serious impact on the viability of their business, because they had to, in essence, relaunch. You know, 1 minute everybody knew them as ABC, and the next minute they're called something different. So it had a significant retro or going backwards type impact on their brand and ultimately their financials.
Sadly, that's a all too common occurrence.
Mm.
It's also another good example of a comparison between an unregistered and a registered mark. And maybe this also comes back to answering Jude's question, is if so I don't know what company Rod's talking about, but if we say that one company was dealing in high-end fashion gowns that sell for $10,000 each, and the other one is selling $5 t-shirts. If I'm the high fashion brand selling those really expensive dresses, and I'm relying on my reputation only, Rod, can you just go on mute for a minute, please? Thank you. Yeah, if I'm the high fashion brand relying only on common law rights, then where's my reputation? My reputation's in selling those high-end things. Are people really going to be confused when they see someone selling a $5 t-shirt? Are they really going to think that that's me? Possibly, but probably not. Whereas if I'm a high fashion brand and I have a registration that covers clothing, my clothing registration covers my high fashion, but it covers every clothing. And so that's just, I hit the t-shirt guy over the head with my trademark registration without having to demonstrate reputation, because he's using the same mark in respect of goods for which I've got a trademark registration.
Can I try again? Can anyone hear me now?
That's better.
Okay. Thanks, Mark. My question is, can a name be registered as a name within a logo which makes it distinctive? I can just hold up my one as an example. I don't know if you can see that. So that's my business name, Impact Stories, but it's within a logo.
Your screen is frozen, but I understand the question.
Okay.
The short answer is quite possibly. So if you've got a name that would otherwise be considered incapable of distinguishing, the way that maybe you can make it distinctive is by putting in a logo form. So remember when we were talking about distinctiveness, the question that the examiner is asking is, would another trader acting only with proper motives think of the mark and want to use it in respect of their goods and services? That's kind of the test in a nutshell. So they're not just talking then about would they want to use the name, would they want to use the whole of the mark? So the more distinctive material you put in the mark, the more likely that it's capable of distinguishing. So that's the good news. The bad news is the more distinctive material you put in the mark, the harder it is for someone to infringe it. Because if someone is just using one of the names, so let's say I want to register Williams, and to do that, I put a whole lot of logos or images in there to make the mark as a whole distinctive. That might mean that I can register my Williams with a picture of an elephant and a duck and a crab and all that. Maybe that's enough to make the mark distinctive. But would then someone who just uses the word Williams be using a mark that's deceptively similar to all of my thing? So the more you have in there, the easier to register. But the more that's in there, the harder for someone to infringe.
Which is a good thing, right? Which
well,
would be a good thing.
Sorry, Sina, you're dropping out again. It can be a good thing. It can be. Obviously, you want to get the broadest protection that you can. You want to get the most bang for your buck.
Yeah.
So often in a situation where there's a mark, in an example where you've got a mark where maybe the mark on its, the word on its own is potentially problematic, maybe it's, I would say, and obviously there's always a cost issue here, let's file for your word and for the combination, because hopefully we can at least secure protection for your logo and get you some protection while we work on your other one. And to work on the other one, might be that you're going to have to use it. You're going to have to use it for 2-3 years. You're going to have to show this is the sales that I've used, and because now, because of the amount of use that I've made, people now recognise it as being a brand.
Right. Okay. Thank you.
Any other questions? Alrighty. Well, again, thank you, Mark. I think we all learned something, and again, we went through this a couple of months ago. There's a couple of things that I picked up. It takes on average a few times for me to pick things up, but there was reinforcement of a lot of the messages we had from a couple of months ago. So for the benefit of everybody, this has been recorded, so we'll be able to distribute it and have access to it. If you missed something through the presentation, we'll also provide access to Mark's details so you can chase up. Beyond that, just letting you know that our own Linda Wilson will be presenting the next one, the next webinar on her superpower being mental health, but really trying to put a business benefit, business impact to that equation. So if you haven't registered for that yet, get on to your advisor, if not the business community, and register your interest for that. So again, Mark, thank you for your time. And
thank you very much.
Thanks everybody for attending.
Yeah, terrific. Thank you.
Okay.
Cheers.
Thanks, everyone.
Thank you.
Thank you.
Bye.
See you, everyone.
I can quite easily see.